My name is Alexandra Harton, certified legal intern under the supervision of Deputy Attorney General Elizabeth Renner for respondent. In this case, the trial court did act within its discretion in allowing expert testimony by Animal Services Officer Morris that the injuries sustained by Max the dog under appellant's care were too severe to have been caused in the way that appellant described. Officer Morris's testimony was based both on her direct observations and on her extensive experience with similar cases, making her qualified to offer her opinion on the severity and on the possible causes of Max's injuries. Even if we do consider the possibility of error in admitting Officer Morris's testimony, any error was harmless, as this was a singular statement by Morris on recross, and it did not affect the results of the trial in light of the overwhelming evidence that appellant used so much unjustifiable force as to actually crush Max's spinal cord, which led to the dog's rather painful death. First, the trial court acted within its discretion under Evidence Code 720 and 801 in allowing Officer Morris's testimony. The decision here is subject to deferential review for abuse of discretion, and in this case, there was no such abuse. Officer Morris's testimony qualifies as expert testimony because her extensive experience in animal services provided her with a specialized knowledge of the case. In addition to her comprehensive formal training, Officer Morris investigated over 200 dog bite cases and nearly twice as many animal welfare cases during her 2.5 years as an animal services officer. She personally handled cases involving dogs with various trauma injuries, including a neck injury like the one sustained by Max, and also consulted with colleagues in other agencies on multiple cases involving dogs with similar neck injuries like this one. Both of which were caused by accidents and by cases of intentional abuse. Moreover, Officer Morris had particular experience responding to situations where a person was injured when they were attempting to pull their hand away from a dog bite and the dog would not let go, as appellant claims was the case here. And so she had personal knowledge that the injuries she observed in those cases looked very different from the injuries incurred by appellant. As held in People v. Williams, an expert's qualifications must be related to the subject of their testimony, and Morris's experience in handling both animal injuries caused by humans and human injuries caused by animals clearly fits this criterion.
Not to get too technical, but depending on the kind of work you do, your skin can get thick and calloused. You can play guitar and maybe your thumb gets a little callus on it, and maybe a dog can't bite through it. I don't know.
Yes, but in this case, appellant's injuries were so minor, not only were they not bleeding when Officer Morris arrived, but they were actually so minor that Officer Morris couldn't even see them. He had to point out where the thumb scrape occurred, and that's why the injury was classified as a tooth scrape, which is when the first layer of skin is removed, rather than a bite mark. And this is what led to Officer Morris's conclusion that the injury was not deep enough for the dog to have held on and be shaken with such force as to cause the trauma it suffered. Something else must have happened, or else she would have expected to see appellant suffer a much deeper bite mark if this dog was holding on for dear life while being shaken. And actually, this amount of force was confirmed by both other veterinary experts, Dr. Wayne Berry and Dr. Mohammed Sharir independently corroborated the severity of Max's injuries and aligned with Officer Morris's conclusions, which also undermines appellant's account of the accidental injury theory. Specifically, Dr. Berry testified that it would take considerable force to cause such injuries. And similarly, Dr. Sharir testified that an injury like the one Max suffered is generally caused by a severe trauma from a severe impact, a snap, or a sudden force akin to that experience during a car crash.
Is that what you're referring to, that evidence, when you talked about harmless, this would be harmless error?
Yes,
because that evidence
I
already
jumped ahead a little bit, I apologize.
Just wanted to clarify, go ahead.
Generally, Morris's practical experience directly related to assessing the types of injuries sustained under such circumstances and how they were caused. And this experience allowed her to offer a reasoned opinion on whether the injuries were consistent with appellant's narrative.
Ms. Harton, you heard your colleague, Mr. Lubner, talk about harmless error. tell us how, if at all, the fact that the question that elicited the objectionable testimony was offered by, the question itself was offered by the defense attorney. Does that impact the analysis in this case at all?
Yes, actually. Any error that may have occurred here was invited by the defense's tactical decision to elicit the testimony that appellant now challenges. Under People v. Cooper, an error is invited if counsel makes a conscious tactical choice. So, in this case, it was not a situation where the defense counsel merely asked a question and then acquiesced to the testimony. Rather, Officer Morris testified that a minor injury like appellant's, in which the dog's tooth merely scraped across the skin, was not consistent with Max latching onto the thumb and being shaken for his life, as appellant claimed. And it was only when defense counsel pressed Officer Morris about why she found appellant's story implausible that Morris explained that hitting the wall would not have caused Max such severe injuries unless he had been lifted airborne. So defense counsel actually asked Officer Morris 8 questions related to her opinion before finally eliciting the statement that is now in question. Given the amount and the intensity of the questioning on the subject, I think the record indicates that the defense made a strategic decision to probe Morris's opinion on the severity and the cause of Max's injuries in order to make the jury question Morris's underlying assumptions.
At the end of the day, the defense could still object and move to strike the testimony for lacking foundation, so, correct?
Yes, correct.
So at the end of the day, really, the only thing that matters is whether there's an appropriate foundation for this testimony, for these opinions. Correct?
Yes, and the state believes there was an appropriate foundation for this testimony considering Morris's significant experience. It's also notable that appellant did not challenge Officer Morris's qualifications to classify bite injuries on humans based on her experience responding to dog bites. So her background responding to dogs who were injured by humans qualified her to testify about those canine injuries in the exact same way that her experience responding to humans who were injured by dogs qualified her to testify about those human injuries, which wasn't challenged. Moreover, the error was harmless because the jury received a thorough cross-examination of Officer Morris, along with detailed jury instructions, which explicitly instructed them that they were not required to accept expert opinions as true or correct. They could disregard any opinion as unbelievable, unreasonable, or unsupported by evidence. So even if the jury had chosen to ignore Officer Morris's testimony per these instructions, the testimony from Dr. Wayne Berry and Dr. Mohammed Sharir independently corroborated the severity of Max's injuries and aligned with Officer Morris's own conclusions, undermining appellant's account of the accidental injury theory. Even the defense expert, while they acknowledged that it was impossible to determine the exact amount of force used, did not provide any alternative explanation that would have aligned with defense's story, or with appellant's story, I'm sorry. So in the matchup between the competing veterinary experts, it's not reasonably probable that a single comment by Officer Morris on cross-examination would have tipped the balance for the jury. And furthermore, consistent with the various experts' testimony, common sense dictates that a minor tooth scrape on appellant's thumb was not deep enough to have allowed Max to held on while being shaken in such a way that he sustained life-threatening injuries. Finally, as the prosecutor argued, the jury could find that the prosecutor argued that the jury could find that appellant used unjustifiable force, whether Max's injuries were caused by him shaking Max violently, throwing him against the wall, swinging him into the wall sideways, or a variety of other manners. So it was not even necessary for the jury to find that appellant actually picked Max up and threw him against the wall, as Officer Morris posited based on her experience. Given the state of the other evidence, any conceivable error in the admission of Officer Morris's testimony was harmless. Happy to answer any further questions.
I'm not seeing any. Okay,
Thank you. Respondent submits.
thank you.